space, the final frontier. We are all interested about, the usual questions, who owns the moon, but yet today we're not really going to be diving that much into that topic, but rather introducing everybody, the whole audience, to what the space law actually presents, what the space sector is. Perhaps we're going to be touching upon what is there to regulate right now, and what activities we have that need to be regulated, and how do we deal with those stuff. So I would actually invite on this virtual session to be joined by Professor Von Der Dank, Alexander Soucek, Jenni Tapio, Christopher Newman, and Rebecca Bresnik. I hope you're all with us already. Let me just take a look at that very briefly.
Hi, Anya.
Hello, hello.
Good morning.
Right.
Good morning or good afternoon.
So we have everybody. Oh, I love your backspace virtual background. That looks amazing, Jenni. So yeah, I would very much like to invite all of our panelists to briefly represent themselves, if that's okay with you. All of you have been invited because there's been a lot of talk from different various continents, and just to give the audience the idea, we have people that are coming from space agencies. Alexander Soucek is here presenting the European Space Agency. We have Rebecca Bresnik coming from NASA. We have Jenni Tapio coming from the Ministry of Finland. And we have two professors with us, that is Christopher Newman and Franz Von Der Dank. I'm just going to briefly look if Nicholas Pushamn, oh, okay, hi, Nicholas Pushamn, you're joining as well. Thank you so much for coming onto this panel. So Nicholas Pushamn is here with us as a trainee solicitors from Bird and Bird, representing the industry sector as well, the private sector. So let's just start with you, Nicholas, if that's okay.
Yeah, sure. Hi there. Thanks, Anya, for the invitation to participate today. Just a brief background on myself. So I'm a lawyer at international law firm Bird and Bird in their London office, and one of my main areas of focus is on the satellite industry. And in that role, I'm involved in advising a range of clients, so government clients, international organizations, as well as private satellite operators, and also telecom companies and other companies that rely on space technology to provide their services. And it's a really interesting job. It's really fascinating to work with so many different types of clients around the world, and to understand the role the law plays, the law and regulation plays in helping these companies and helping these clients, develop their services, develop their products. And I think we're a really exciting time right now in the space sector. I mean, like everything, it's been somewhat upended by what's happening in the world with this global pandemic. But I think there are many signs in Europe and in the UK, certainly, that space is a really important sector, and there's a lot of interest in it across government. But before I became a lawyer at Bird and Bird, I agency. In fact, my former boss, Alex Soucek, is on this call, so very nice to see him. And in that role, I also helped run the European Centre for Space Law, which is one of the leading centres within Europe for space law education and knowledge. And I'm now very privileged to sit on the board of that organisation. And my experience before that was quite varied. I did a lot of different legal internships and tried to get as much experience as I could across many different areas of law. I also worked in a specialist consultancy firm doing mostly satellite and space projects, and also spent some time in an academic capacity doing research when I was doing my master's in space law. So there has been quite a focus on space and satellite throughout my career so far, and I certainly hope that continues, because it's a very exciting sector to be involved in.
Thank you so much. I actually met you when we were having a moot court competition. So that was when we first went to Paris and heard the legal symposium on the space law. It was quite incredible. The whole competition was extremely well organized. So congratulations for that as well. And as you mentioned, your previous boss was Alexander Soucek. So I'm just going to be inviting and bringing people on board in the consequence, not the consequence, but the sequence that you proposed. So Alexander, please join us and tell us more about yourself.
Thank you, Anya, and good afternoon to everyone. It's really a pleasure to be here on this panel. Thanks, Nick, also for explaining to the audience what career someone can take that might start at ESA and then lead you somewhere else. For me, it didn't. So I got stuck in ESA, basically, when I started as a young graduate almost 20 years ago with the European Space Agency. And my current position there is I'm the head of the International Law Division of the European Space Agency. For those of you who are not familiar with ESA, it's an interesting animal because opposite to NASA, another and the most famous space organization, I would say, to everyone, ESA is not a national body, it's an international, intergovernmental organization. So we represent 22 different member states and of course also their ideas, their industries, etc., which is sometimes quite a challenge to bring all of those approaches under one roof, but it's also a fascinating journey we are on every day. And international law itself plays, of course, a big role in that. ESA is not a regulator, so we are not telling member states what to do and how to do space, but we're helping them in order to implement international space law. And of course, being a subject of international law ourselves, we have to comply, and we want to comply with international space law as well. And maybe just one sentence on my professional background. So yes, obviously I'm also a lawyer, but I also studied and have a master in space studies, space sciences, which helps me a lot because I think especially this topic is really an interdisciplinary or multidisciplinary one. And it helps a lot to know the technical reality of things that you as a lawyer negotiate and talk about. So this is really wonderful. And that goes up to my little own telescope I have on the balcony as a passionate hobby astronomer. Thank you.
That is so great, and very much aligned with the Future Law Virtual Summit. I mean, we are all about the complexity and different system thinking and bringing all these different disciplines together. Perhaps some of you that have been with us for these 4 days already know about just how big of a variety we're bringing into this space. And this just leads me directly to another person that I've also had a pleasure to meet previously at one of the legal symposiums back in ESA again, Jenni Tapio. Do you want to tell us more about yourself and what you do?
Hi, Anya, and good afternoon to everyone, and greetings from Helsinki. Yes, so I'm not so lucky to have worked with space my entire career, but currently I'm working with the Ministry of Economic Affairs and Employment in Finland, and being responsible for our national space legislation, and also representing our government at the United Nations Committee on Peaceful Uses of Outer Space, the COPUOS committee in Vienna. And I'm also currently a lot working with ESA, so I'm sitting at the International Relations Committee, which is a fascinating body where we can then discuss these different ideas about international space law and policy. But otherwise, my work relates a lot about the authorization and supervision of our national space activity. So I'm responsible for overseeing our national space law and the development of that going forward now that we've had that in force for the past 2 years. But before becoming part of space, I worked at Nokia and Airbus as an in-house counsel, and also as an attorney at Bird and Bird, where Nick currently is. So it's really a small family within space here in Europe. I guess that's it. Looking forward a lot to discuss with everyone on this interesting topic.
And before moving forward to the academia, I'm going to be inviting Rebecca Bresnik to actually share something about yourself as well. How's the work at NASA?
Good morning. Well, good afternoon for you. This morning it's nice to see some familiar faces. Alexander, I haven't seen you since I think our time in Nordvik together. And I work a lot with all the space agencies, ESA, Roscosmos, the Japanese Space Agency and the Canadian Space Agency. And we just actually are at the end of working a very large project, the Gateway, which is going to be our new lunar platform going around the moon. So working for NASA, I'm lead for international law down at Johnson Space Center. And so I'm in Houston, Texas. We have 10 centers overall. And similar to ESA, we're not a regulatory agency, we're a civil space agency. And I've been a lawyer with NASA for approximately 16, 17 years now. Before that, I was actually the opposite of Nick. I was in industry and then went into the government. And I worked for a company called Northrop Grumman, which is an aerospace company. But then before that, I actually was with the government working for the Department of Defense. So I was government, went back out, came back in. I think also what I heard this morning is just what an amazing time for space it is right now. And we had the IAC last week, and just hearing about the future exploration, what countries are doing. I mean, it is just, and not just countries. What I think is so amazing right now is what companies and what industry are now doing in space. So it's just a really phenomenal time. And just, I look forward to talking on the panel, hearing what everyone else's thoughts are on space and the future, and again, just getting everyone's perspective on that, on the future of the new frontier.
Thank you so much. And yeah, I do invite everybody to join me in writing into the chat if you have any questions that pop up along the way. Don't be afraid, put it in the chat. We have moderators for the chat, and we're going to be proposing these questions to the panelists at the end of the discussion as well. And now I invite Christopher Newman to tell us more about what the professor lifestyle looks like.
Hello, Anya. Hello, everyone. Real honor to be on a panel with such an amazing group of people. I have to say, I always feel a little bit of an intruder, a little bit of an imposter when seeing some of the greats of space law and actually, people who are doing space law. It's wonderful to see. It's also wonderful to be part of a panel at this time because, as has been said, there's so much happening. There's so much we've got to look forward to in space exploration. One of the big sort of challenges, I think, that sort of my research has pulled up is that people see space, or have seen space traditionally, as belonging to other people. It belongs to astronauts, it belongs to space agency. And I think that the big challenge we've got, and one of the things that I think we're doing, is making space belong to everyone, making space exploration and space activity something that everyone can have a stake in. And I'm sort of living proof for that. I was an anti-terrorist detective for 6 years, dealt with counter-proliferation issues. That's how I first encountered the space treaties. I then became, sort of big poacher turned gamekeeper. I became a solicitor. I was a lawyer for 3 years, and then joined academia and has sort of pursued my space law studies and pursued my space law research and teaching. So kind of my journey was a bit more circuitous than others, but I'm just happy to be here.
Thank you so much for that. I mean, I did a research and I read your bio, and I did not know that that was actually something that you've done before. So very welcome to share this perspective and to get to know you better. And the last on the panel is Franz Von Der Dank, which is also one of the great authors and one of the people that you used to read as a student, or I used to read as a student. And I must say that every single person in this panel actually inspired me in some way. And this is pretty much why I went into space and still am very much fascinated about it. So Frans, please share a story that you have.
Okay, well, first of all, hi to so many familiar faces that I've seen over the last decades, probably. It's always nice to be in a panel like this. And but for those who don't know me yet, you can't see it, but I wear two hats. So the one hat is the academic one. I'm a professor of space law at the quite unique space, cyber and telecommunications law postgraduate program at the University of Nebraska in Lincoln, in the middle of the United States. which is where I do my teaching. We have alumni now working for the major US companies, for the US State Department, for international organizations, etc., etc. And my research, you already referred to my writing. I'm particularly proud of the first handbook on space law, which I not wrote, but largely edited, although I wrote some parts of it as well. And just more recently is my advanced introduction to space law, which is kind of a less ambitious project, not 1,000 pages, but merely 50,000 words. But so these are the kind of things that we do in Nebraska, and I'm of course then responsible mainly for the space law part, although my colleagues dabble with that from time to time as well. The other hat is my consultancy company, which is part of the reason why I'm still basically located in the Netherlands. And Nicholas has already pointed out to some of the things that that consultants do. Just to give you a little bit more on that, I've been doing this for almost 30 years by now, and it ranges from small, you know, a couple of day assignments for companies who want to know what their liability is in case they want to launch a piggyback secondary payload on a primary satellite, and they have not even heard of what a launching state is yet. So I tell them what it is and what it means and what they have to do to take care of it. Two major projects I've been involved almost since the beginning with the legal implications of Galileo, the second generation GNSS, which the Europeans are going to send up and running, or are sending up and running as we speak, which raises a lot of legal issues, as you can imagine. I've consulted with at least half a dozen countries on national space law. That ranges again from giving some advice from a distance, maybe you better do this, or maybe you better take care of that, to actually writing. In the case of the United Arab Emirates, I basically wrote the first draft of their national space law, but then was at pain to see that the politicians ran with it and made something rather different out of it. But I guess that's the fate of a consultant. So it testifies, chiming in with what the rest of the panelists have already said, it chimes in with the fact that space law is growing. 50 years ago, it was all about a handful of countries and a handful of treaties and basically not much more. Now we don't just have more than a handful of countries, but literally dozens of countries. And in addition, we have the private sector, which is of course also where private national law, Jenny referred to that in the Finnish case, but there are by now more than 24 countries who have a substantial body of national space law regulating their own private sector entry into space. So that is something which is clearly growing, and I'm always telling my students, I've been telling them this for the last 10 years, I should confess, but you're on the cusp of a great growth in space and a need for space lawyers. So this is really a good moment to jump into the game. I'll leave it at that. We can come back to some issues later in discussion, but this should suffice for now. Thanks.
Absolutely. Thank you so much. And while we were discussing a couple of times that with Nick, actually, a question came up. What actually is a space sector? And is there any, you know, I mean, I know that Frans created a whole handbook, which I perceive as a Bible of the space law. But really, what drew us to compose such a huge repository for all these laws? What are we regulating? Nick, can you take on that?
So I think the first element of your question, Anya, is about what do we have to mean when we're talking about this sector, this industry, all of these terms that are used. And when I think about the job that I'm doing, I don't really like to use the term space lawyer because I don't actually think it's very accurate. I mean, I think that space law as an area of law is an accurate term, but not so much space lawyer, especially when you're in practice like I am. I prefer to use the term you're a lawyer who just happens to work a lot of the time with this particular industry. And so I think the space industry, like any other industry, can be measured. And there are a lot of very useful studies and initiatives underway right now, both from private consultancy firms and also organizations like the UN, looking at things like the global space economy. A lot of international organizations such as the OECD also have initiatives looking at the space economy, which I think just demonstrates the interest that so many people are taking in this growing sector. But one one reference point I look at on a yearly basis is a company called Bryce Space and Technology, and they publish a report every year called The State of the Satellite Industry. Now, they talk about the satellite industry, but they also look at the broader space sector. And what those studies show is that it is growing from year to year. I think the most recent study showed that globally speaking, the space sector is worth over $270 billion a year in terms of revenue, which is split across satellite services, ground equipment, satellite manufacturing, and also the launch industry. And I think that's the international sector, and those are the statistics that you can find for that. But then looking at the sector at a national level, you can also see that in many countries it's growing. So the sector that I'm most familiar with, because I'm a lawyer in the UK, is what's happening in the UK industry. And that's also an example of a sector that's growing. It's not anywhere near $270 billion, but it's currently around 14.8 billion pounds by last estimates. And I think it's interesting to look at this sector from an international point of view, but then also regionally, so within Europe, and also at a domestic level, because you can see that countries also differ in what they define as the key elements of that sector. So for example, in the UK, the launch industry, until recently at least, has not been a huge contributing factor in the annual space revenues. Rather, in the UK, space applications has been a larger contributing factor to what's made this industry a growing one in the UK. And so, if you understand what the sector is you're looking at, you can then understand what actually needs to be regulated, and why we have national legislation, for instance, and why we have other types of law and regulation. And I think if you look at something like this, like a satellite mission, if you break that down, you can understand the different elements of that require a form of regulation. So for instance, you have the communications between the ground and the satellite, which requires in many countries a license, because the spectrum is regulated. You may also require a license to actually launch the satellite into orbit. And you may need other licenses as well, and therefore other regulations come into play when it comes to the operation of that satellite. So I think the question of what is being regulated can be quite a difficult one to answer, because if you're talking about a private commercial space mission, different elements of it are being regulated. If you're talking about a country carrying out its own space activity, then what's being regulated there might be slightly different.
That's incredible. And since you're mentioning the space objects and all these space satellites that we're launching into the space, I wonder whether we have a complete repository of those, because I saw that there's, for example, an app, and I can just take a photo of the space and the app is going to be telling me what satellites are above my head. And then half a year ago, we had a lot of people calling us and saying, hey, I see aliens on the sky. And it wasn't really the aliens, it was rather the SpaceX satellites. And I just wonder, do we have like that type of a repository? Alexander, I know that you were part of that, or at least you might be telling us more about the register that has been established in the ESA a few years ago, like a very comprehensive one.
Yeah, thank you, Anya. It's a good question, and it depends. For lawyers, everything always depends on the word complete. Do we have a complete repository of everything that's up there? Because there we have already to start to distinguish. There are active satellites out there, and satellites, by satellites we mean artificial, human-made objects that are actually going around a planet, a celestial body, so that are orbiting it. That's a satellite. Can be also around the moon, doesn't have to be around Earth or around Mars. And then we have other spacecraft that are crossing the solar system, which are for us not satellites, but space probes or deep space probes. But anyways, there's a lot of that stuff up there, both, as I said, active ones, so satellites or machines that actually deliver data that are working, that are being controlled. But then there is a even much bigger population of objects that are not functional anymore, not working anymore, that might even have disintegrated. And so we see the remnants of these objects still up in space because they stay there for a long, long time. And we refer to that as space debris or orbital debris. And so now to your question, do we have complete repositories of all that? In terms of active satellites, there is actually a United Nations treaty, a treaty that has been negotiated under the auspices of the United Nations. And that is the Registration Convention that asks or obliges, to be very frank, that obliges its member states, so the state parties having signed up to that treaty, to register each object they send into orbit, into outer space, by means of an entry in a national register. But even more than that, to notify the United Nations of that space object launched, together with a few parameters like the orbit, date of launch, the launching state that Frans has just mentioned before in his introduction. And so if you go on the website of the United Nations Office for Outer Space Affairs, you'll find there a link that will lead you to the UN Space Object Register. It's called the Online Index on Space Objects. And there you will see a lot of these satellites together with all the information that a government sent to the United Nations and that is put in that register. Now, is that complete? No, it's not complete, because sometimes these registration or notification processes take a long time. Often the information you have on there then a few years later is not anymore up to date. So it's not telling you where that specific satellite is right now in that moment, because that's of course subject to a lot of forces that act upon the satellite. Every moment it rotates around Earth. And for that, space agencies or governments, those with the specific means in place, have also other national registers where they can follow and track such objects, especially important for space debris, like in the United States, in Europe. We have also these catalogs, very different from the UN catalog I just described, where we have very accurate information on space objects and debris, so elements of those objects, and where they are right now, because that's most interesting for collision avoidance. We don't need to know if something has been accurately registered 11 years ago with the right letter subject. We need to know where that object is in the next 12 hours and if it could come too close to another object. So with that, I conclude. Several repositories from several entities telling us things about the location and identity of objects in outer space.
That's incredible. I mean, I spoke with our ministry here in times when they were composing the space regulations for Slovenia, and we raised that question of how the registry is going to be looking like on the national level. And people were just looking at us saying, but we only have 2 satellites. It might as well be just a book, a very small one. And we type everything down. But at the same time, I mean, it sounds important, especially knowing that satellites can have different materials on them. And in terms of, you know, what happens if they collide, that might be a very important element or characteristic to have at hand. And now that you mentioned the collision of these 2 satellites, I know that last time on the first panel, we actually briefly spoke about that. And Frans, if my memory is not mistaken, you actually wrote a very interesting article about the misconceptions and misinterpretations of the liability and responsibility in space. Would you mind explaining a bit more about how the liability and responsibility differ from each other and how that actually looks like in space?
Ooh, you're touching a very difficult subject, because before you know it, I need half an hour to spend on that. I'll try to keep it short though. The idea of responsibility comes from general public international law, where you have this concept of state responsibility, which makes states responsible, directly responsible for their own activities. And they should be held responsible in particular in case they violate international obligations towards other states. So the trigger of responsibility is a violation of an obligation to another state. So if there is an obligation in the Outer Space Treaty not to harmfully interfere, if there is, because there's questions whether there is actually such an obligation, but if there is an obligation not to harmfully interfere with other states' activities, then of course the moment that you do that as a state, you are responsible, and you have to redeem that responsibility by a certain limited number of actions at your choice, taking away the illegality of the action or redeeming it. Liability is a concept which is much more known from national law, and is triggered by damage. Somebody causes damage to something and somebody has to pay for that damage. Whether it's unlimited compensation, whether it's absolute or fault liability, all depends upon the regime. And one of the problems in space law is that the two do not exactly see eye to eye. So when you talk about a particular space object or a particular space activity, you might have, in many cases, certainly with today's very complex international environments, a different set of states being responsible for the activities as compared to the set of states which might be liable for the damage caused by them. Because to go to the positive side of how space law treats these things, both in state responsibility and in state liability, it pertains also to activities of the private sector. So if Boeing does something which is illegal under space law, anyone having an issue with that can directly claim against the US government, hey, take care of your own sheep, make sure that Boeing doesn't do anything which violates our rights in outer space. And that is part of why the United States has to regulate what Boeing is actually doing, because they obviously want to be able to control that Boeing doesn't do anything illegal in outer space. And the same basic concept also applies to liability. If a Boeing satellite crashes into Mexico, the victims do not need to go to a US court and sue under tort law directly against Boeing. It's the Mexican government which can assert directly a claim towards the US government. And the US government can't say, well, you know, this wasn't us, this wasn't NASA, this wasn't NOAA or the Department of Defense, this was some private company. That's the problem of the United States. So again, that's where national space law comes in. And in that sense, I think it's one of the beautiful aspects of space law that the burden of responsibility and liability clearly remains at the level of states, which, for example, is a major reason why I'm not so afraid that we will see things like flags of convenience, which is, of course, a major problem in the law of the sea, where you have all these cheap flag states which float around on the oceans without appropriate safety guidance and things like that. I don't see that happening too easily in outer space, because the burden will always be on the state if something bad happens. I hope that was still a short lecture, but I'll hand off here to you, Anna.
Thank you. That was quite incredible. Yes, absolutely. And we also have 2 questions from the audience. So I'm just going to be posing one to you, Jenni Tapio. Knowing that you work with the governments, you might actually be the most suitable for answering that, right next to Rebecca. Also from a national perspective, how do national legislators and regulators find the balance between different interests? So for example, in the UK, you have one of the main economical research, and then the UK is being involved also in the OneWeb. So I guess the question might also be, how is the government looking into private sector and balancing it with the national interest?
Thanks. That's certainly not the easiest question, but sort of like referring back to what Frans was just explaining about the liability and responsibility regime. I think, of course, from state's perspective, these are the main considerations. The risk limitation of activities of the national non-governmental activities is one of the let's say main motivations for making a national space law. But then, of course, you have to balance exactly that with the interests of the national subjects that would want to carry out such activities, and how to at the same time incentivize and support that business activity while at the same time limiting risks. So there is, of course, a careful balancing exercise already done at the level of the law, but also at the level of each licensing decision. And that, of course, requires a lot of competence and information on the part of the regulator to understand that the technical and legal issues that relate to each and every mission, and as well to the implementation of the national space law. But of course, this is not only at national level, but also an issue that states together should deal at international level by discussing with one another. And just referring to these flags of convenience topic, that you know, in a case we could have similar laws in all the countries that would put similar obligations on the companies, this could, on its part, alleviate the issue of possible flags of convenience, and anyway bring more, let's say, a good ground for these activities that are global in character.
Now, referring to the first question that Juliana Rotola posted, again, about the private sector and the interest, and now talking about the flags of convenience, with Rebecca, we spoke about mining industry, and the US is now looking to go back to the moon and putting a flag onto the surface of the moon. What's going to happen there? Is that also like a private interest to kind of get all the extracted minerals and then do the ownership? Or I know that you're the expert on that, and that you have crafted and written about that on your in your dissertation. So bring us to light, like enlighten us with regard to that topic.
Yeah, so it's a very interesting topic and a very timely topic. And the interesting thing was 16, 17 years ago when I was doing my LLM thesis, it was such an esoteric issue that I never thought I would ever practice in my daily life as being a lawyer for NASA. It's just been very interesting the past 4 or 5 years that this has now come more and more into play in my daily work. As you know, the United States, in this current administration, we now have the National Space Council, and under the National Space Council, the vice president leads that, and they came out with a statement, the vice president and the president, saying that the United States will go back to the moon by 2024. With that, and it goes, I think, into a little bit of the last question, it has really spurred a significant amount of commercial activities. But to get commercial companies interested, and one of the big pushes too with going back to the moon is having a sustainable presence, not going back to the moon and just touching base again and then leaving. It's how are we going to have a sustainable presence on the moon? And one of the ways that we are looking at, and the important things, is the extraction of minerals, of resources. But to do that, you have to get companies interested and wanting to do those activities. And there does have to be some sort of economic benefit, obviously. So with that, you have to have clear laws on ownership rights of resources. And I know there are differing opinions on this from different countries, and of whether or not the Outer Space Treaty in Article 2, where it talks about national appropriation, whether or not that means national appropriation means no one can appropriate the land and the resources as well, and can there be private ownership of natural resources extracted from the lunar surface or any other celestial body. And the United States in 2015 passed a law that allowed for private ownership. And we have interpreted the Outer Space Treaty to allow for that. And then in addition to that, we've recently passed an executive order reinforcing that. And then more recently, we have a treaty called the Artemis Accords, which actually was introduced last week at the IAC, which talks about major principles of how the United States views on major principles of activities on the lunar surface, to include the ownership of resources, being able to own and use resources when we go back to the lunar surface. In addition to that, NASA recently put out a solicitation of calling for any companies that can go to the lunar surface, extract resources, and give those resources to NASA, to the space agency, and we would take ownership of those resources up on the lunar surface. Again, I know this is a fairly controversial topic. We have the Moon Treaty as well, and the Moon Treaty talks very differently about the ownership of natural resources, where in Article 11 of the Moon Treaty, there's the call for a larger international organization that would determine the handing out of those resources, the ownership and delving out of those resources, more different than the US, which is allowing for individual ownership. So again, you might want to ask some of the other panel members of their viewpoint. I know, and I do have to say, my viewpoints are not the viewpoints of NASA, so I do have to separate those, obviously. But yeah, it's a, the question is, though, how do you explore and how do you get companies and industry involved in exploring and wanting to invest their money without giving them ownership rights? The companies aren't going to want to be involved unless they see the benefit. And I know there's the argument too, well, then are we now going contrary to the Outer Space Treaty, where, one of the major premises of the Outer Space Treaty and of outer space, it has to be for the benefit of all mankind. So the counter argument, well, the companies going up there and extracting minerals and bringing them back to the United States for a purpose, possibly an energy resource, or possibly a resource that allows for rocket fuel on the lunar surface so we can explore beyond Mars. The argument is allowing for that is for the benefit of all mankind. I think I'll stop there.
Thank you so much for that. And I know that there is plenty of responses that we can hear as well. So I'm going to give a word to Frans, and maybe Nicholas, you want to add something afterwards?
Thank you. Yeah, just to back up on what Rebecca said, and going back to your original question, Anya, you mentioned that there was a flag going to be planted. And I just want to make sure that that doesn't give the wrong impression. That has happened before, of course. If we go back to the 1969-72 framework, the various moon landings planted US flags on the moon. But contrary to history on Earth, the United States has always made it pretty clear that that didn't mean that they were claiming the moon or anything like that. So contrary
Absolutely.
to the Russians, who recently said that Venus was basically their planet because they crashed there, they were first to crash something into its surface. The United States made that point very clear, basically the US flag was only there to honor the US taxpayer, who after all had ponied up the billions of dollars to get the astronauts there. I'm going to go into more detail tomorrow in my keynote, but I just wanted to leave no one under the impression that planting a flag on the moon means that you now have a colony there.
So I absolutely agree with that as well. Thank you for sharing those thoughts.
And Nicholas, did you want to say something in addition to that?
Well, not really about the substance of this question itself, because I think people like Alex, Becca, Frans, and Chris and Jenni are much more expert on this particular topic. But I would make a comment just about the Artemis Accords themselves, because when those were signed last week, and the UK was one of the signatories to those accords, I saw some commentary about, well, does signing up to these accords indicate each country's viewpoint on the legality of space resources, for example? And I don't think that's quite the case, because as I understand it, the accords themselves are not a treaty, they're a political commitment, and so they aren't binding on each of the countries. They don't have obligations on each of the states to implement those accords and ratify them into national law like you would any other treaty under public international law. And I think what happened when these accords were signed was really interesting, because even though it's not binding international law, it does show the importance of international cooperation when it comes to such bold endeavors like this. And at a time when so many countries are taking quite a nationalist approach to their economic activities, and also to some extent their space activities, I think that the signing of these accords was a good reminder that actually, you know, at the heart of space lawmaking and diplomacy in this particular area, international cooperation remains as fundamental as it ever has. And so I thought that was very interesting. And the last point I would say, and perhaps all the other panelists would agree to this, I don't think any of us are speaking on behalf of the organizations we represent. I know that Rebecca made that clear in relation to NASA, and I would just say it to myself as well. This is very much personal viewpoints. I don't represent a government agency, so maybe I'm not as at risk, but I just want to make that very clear as well.
Yeah, thank you so much for that. We also have a question from Helte Osborne. It seems nations, academics, and commercial actors all agree that we need an international space traffic management system, or short of that, better governance guidelines that are internationally agreed upon. Now, I do want to pose that question to Christopher Newman. A new regime has not emerged. What are the barriers to agreeing on the international system like that?
Okay, so I think the first thing that that I'm going to say is I'm going to take a step back to your other question about the register and what's on the registry. What the registers tell us is a partial picture of what's up there. What they don't tell us is where it is. They don't tell us where the different objects are. And actually, I think there's sort of general consensus amongst the SSA, STM. I'm using these abbreviations, and it's just because I want to be quick and not take up too much time. But when I'm talking about SSA, space situational awareness, understanding what's going on in the orbits of the Earth, and STM is the space traffic management. I think the military also call it space domain awareness, but I'm not really interested in what they do. But in order to understand how we can sort of influence behavior, we firstly need to measure what's going on up there. So I think one of the first barrier I would say towards effective space traffic management is a lack of awareness of what's going on in space and a lack of understanding. The space trackers call it persistence of observation of objects, and there isn't that sort of persistence either in GEO or in LEO. So we need to know more about the space environment. That's the first thing before we go on and then think about how we're going to manage it. The next question we have is, what would a regime of traffic management look like? Are we talking about a Wizard of Oz type of character behind the curtain who miraculously gets everyone to control their satellites? Or are we talking about a slightly looser regime where information and data about the Earth's orbits are shared, and then operators and users of space can make up their own minds as to exactly how they're going to deal with it? You know, it's one of the things that we see right even in the Outer Space Treaty, this notion in Article 9 of due regard to other space users. Do we have there an embryonic sort of duty of care on behalf of all space users to each other? And if we do, then the provision of information should be enough to guarantee some sort of embryonic management system. I think the provision of it in a treaty is ambitious. I'll be honest with you. International treaty seems to have fallen out of favor at the moment. So I think more likely what we're going to be looking at is some sort of hybrid agreement whereby operators decide to behave in a certain way. They promulgate a series of rules and governments agree that this is a good idea. That's how I see it developing. I don't see a treaty framework working on this respect because I think too many of the operators are not governmental. So despite the control that governments have over their commercial operators, it's still actually the commercial operators that are going to be doing it. So I think they're the ones who are going to have to, if not lead, then at least have a huge input into any space traffic management system.
Thank you. I hope that answers your question, Kjarte. There was also a question that Amanda Jones had. What happens if a nation objects to the US law, and how can the US determine law on an entity external to its territory? Is that a long-arm principle? Frans, would you know how to answer that?
Well, I'll try at least. And again, I'm going to go into some more detail tomorrow. It's a very interesting question. The point is, of course, that if you read the US law, which actually is one chapter in a US law, which deals with a lot of other stuff as well, but that chapter only addresses the thing of mineral resource exploitation. It does make clear that the US doesn't claim this to be applicable worldwide. It simply says that if we have a dispute between US entities on the rights to minerals exploited, we accept those in principles, and we feel entitled to determine which of the entities has the prior right. That's quite something different from regulating other countries. And obviously, if two Chinese countries claim, or two Chinese companies claim they own resources, it's not up for the US or US law to determine how to solve a dispute like that. So that's the first point I'd like to make here. And the second part of your question, as I read it here as well, is how can the US determine law on an entity external to its territory, this long arm thing? Well, that is not too uncommon. I mean, the idea is, what do you focus on? And the focus of the United States is basically on what happens once these materials are brought into the US market. And then obviously it's part of the US sovereignty to determine to what extent those minerals are validly, are legally obtained and put up for sale. The European Union applies its competition regime to US companies as soon as they enter the EU market, because it's not the nature of the company or the nationality of the company or the home base of the company which counts for the EU. It's the effect on the European internal market, which entitles the European Commission to throw fines at Microsoft and to prohibit the merger of General Electric with Honeywell Bull and things like that. So we must be careful in realizing that when you apply the law, what part do you apply it to? And I would say that in that sense, and it's not just the US law now, by now also Luxembourg and United Arab Emirates have adopted similar laws like that. One has to be very careful in seeing what the extent of this long arm is. So I want to leave it at there, not to monopolize too much of the discussion.
Yeah, and maybe just to add to that very quickly, yeah, and I also wanted to bring up Luxembourg and UAE. It's not just the United States that has a domestic law that allows for the ownership of resources, but even within our law too, it specifically states that we aren't taking ownership that the United States thinks that is contrary to the Outer Space Treaty, so that we do in the law specifically state that we will still be consistent with the Outer Space Treaty. It's not that we've, in our viewpoint, have passed a domestic law that is inconsistent and we're disregarding the Outer Space Treaty.
Thank you for that. We also had a question from Michael, who wants to know more about the regulations surrounding the accidents caused when satellites are deliberately destroyed, but end up destroying other countries' satellites, since there was a recent case with China. And maybe Jenni and Alexander, you can give us a bit more about what the cooperation between states actually looks like in order to prevent that from happening, or what is the case actually? What happens when such a case really happens?
I don't know, you addressed the question to two. So
did you want to go first?
I don't want, but I can, since the mic is open, I can make a first attempt, and then, I mean, the other panelists, I guess, are all perfectly suited to answer as well. So maybe just, this is a question that follows a bit up from what Frans has already explained to the audience. So it very much goes also in the direction of what is the responsibility of states when they act in outer space, and what are the consequences if they cause damage? Now, there is one additional aspect, maybe in order not to repeat things. There are two different liability regimes that apply depending on whether a damage has been caused by a space object in outer space, so two other space objects in outer space, or on the surface of Earth. And the legal conceptual approach is quite different. Without giving a lecture myself, just to say that in outer space, if there is a damage, then triggering liability and holding somebody liable to compensate requires fault of the actor. So you have to have caused damage through faulty behavior, whatever that is. That's part of the problem. Gross negligence, or even deliberately doing something that is harmful to others and has caused damage. It's totally different when we speak about damages on the surface of Earth. That means when a spacecraft has re-entered the atmosphere, has survived the atmospheric re-entry, and then what is left over, burnt, but still causes a damage. Then there is something that many refer to as absolute liability. So we don't ask for fault. It's enough to have caused that damage. It's financially unlimited, and it's even unlimited in time, which is a very victim-friendly way of handling things. And behind there is a bigger social equation that basically says, since there is the freedom for all states to explore and use outer space as enshrined in the Outer Space Treaty, there comes a price with that. And that price, if you so wish, is if others who are not profiting from that freedom have to suffer from you exercising that freedom, from you going up there, and then you drop something on them, then they should have the opportunity to be compensated without having too many hurdles. That's why there is no fault requirement when it comes to damage on Earth. Whereas in outer space, when you collide with another object, then you collide with the object of somebody who is equally profiting same way you are from that freedom going into outer space. So that's something you have to add. So we have to really distinguish where such a damage that Michael in his question is referring to occurs. Now, the problem is with damages in outer space, as I just said, in order to claim liability under the Liability Convention, you need fault. You need to prove, establish fault. And that is not very easy to do, because the question is, what are you measuring against? Any standard protocols? Are they standard in every country? How have those protocols or technical standards been recognized internationally by governments? So what's really the measurement of fault? And that is the first thing. And the other thing is proof of fault, the measurement, and then to actually prove that. So that makes it so difficult that at least up to today, we have had no single triggering of the Liability Convention for damages having been caused in outer space, and also on ground, virtually none. There have been a few cases where, you know, the Liability Convention was mentioned in the way things were settled. But in outer space, since half a century, that's how old the Liability Convention is, 72, almost half a century, we don't have an example of fault being proven. And that's specifically interesting for that case mentioned in the chat, when you deliberately destroy one of your own satellites, and then those elements that are the leftovers of an explosion eventually hit another satellite and disable that satellite. Now, so far, this is predominantly a question you would typically ask law students, then to, you know, make the whole declination. Can you hold that country liable, under which conditions, and so on. In practice, it has not happened. However, if you see the amount of space debris growing, sooner or later that question will be posed, be it a deliberate destruction of your spacecraft, be it an accidental destruction of your spacecraft. The consequences will one day come up at a legal or diplomatic exercise.
That was amazing. Thank you for explaining the liability into details a bit more. But Jenni, do you want to continue just where Alexander's?
Yes, if I may, I just wanted to sort of like follow up on what Alex just left off, that that the breakups may cause space debris, and especially long-lived space debris, which creates problems for all activities, be that of military or civil in character. And I think this is the issue that is usually framed under sustainability, for example, but also relates to issues such as space traffic management that was previously mentioned, is that it's a topic that where the interests well converge between the states and private actors. And here is a way of maybe finding some sort of a way out which could be beneficial for everyone. And I think here is just then the issue that relates to governance. This is the topic that we can currently agree on these through instruments, let's call them guidelines, that are of non-legally binding nature, and how to best, let's say, enjoy the flexibility that is created by the usage of such instruments and the technical character of those instruments, and to nevertheless be able to provide for a clear framework for the private actors to know what currently is and isn't allowed. But I think it's really the issue of space debris that we should, at least from the usage point of view, to address with such tests?
Okay, there's a lot of things happening with the satellites apparently. What do states have to do? What is required from the nation states to actually do with regard to sending out the satellites and having these guidelines implemented on the national level? Maybe Nick, you can actually bring us to that.
Yeah, sure. No problem. I think so many of the discussions that we've had today raise this question about how to effectively regulate the activity, or what laws govern the activity. Is it international, national law? Is it both? How do those work together? And when Alex and Jenni were speaking just a moment ago about the liability convention in relation to the risks of collision in orbit, whether deliberate or unintentionally, it got me thinking about a recent consultation in the UK, which is actually in part looking at how the liability convention should be interpreted according to the UK. And I would encourage anyone that's got an interest in this to have a look at it, just very briefly on a bit of background, and then I'll talk about your question, Anya. The UK has essentially two main pieces of legislation. There's a 1986 Act, which is quite general and creates a licensing framework for space activities in the UK. And recently, in 2018, a new piece of legislation was brought in, which is called the Space Industry Act. And the purpose of that act essentially is not to license all different types of space activities, but to license a new type of commercial spaceflight from the UK. So rockets being launched from UK soil, satellites being launched from the UK, both vertical launches and horizontal launches. And so it's a very interesting development because it really is space law in action at a national level, but it also raises these international questions. So the legislation was brought in a couple of years ago. It's a very big piece of legislation, but all of the implementing regulations that are actually needed for that law to have teeth, to actually operate, are now only being introduced. One of the questions that was raised earlier, I think by someone in the chat, was about how does a regulator balance the interests of, I think in that question it was a constellation like OneWeb and the radio astronomy community. And that's a really important question, because I don't think a regulator is ever going to please everyone. There's always going to be someone that's disappointed because the decision goes against them, and space is not an exception to that. But one way of trying to please as many people as you can is by having a consultation. And I think many countries have consultation processes before they introduce a piece of legislation before Parliament, and then that piece of legislation becomes law. And the UK is currently doing that in relation to a set of regulations which deal specifically with this question of liability. The consultation, which was introduced only last week, and I think is open until November, looks at how to manage the risks, how to manage liability for launches that are taking place from the UK. And so this is quite a new thing for the UK, because we've not had a launch market like they have in France, or especially like they have in the US. And in the consultation document, it's quite interesting because they examine to an extent the terms of the liability convention, those that have been referenced by Alex and Jenni, and they give us some indication of how the UK, as a state party to the liability convention, interprets the meaning of damage. For example, does it include environmental damage, which in this consultation document the UK has said yes, it does. Does it include business interruption, for example, which is not an international law question, but is very much a national question. And so I think it's very useful to look at what's happening at a national level, because in many ways it can help us understand how countries interpret these international legal obligations. And space resources is a great example of that, but there's many more examples where we can see that type of international and national debate. I think if I remember your question correctly, I think yours was about what did national regulations do to actually regulate certain activities. I think that was what you asked, but I'll maybe just talk very quickly about due diligence and the licensing frameworks that countries have in place. And I think space debris is is a really big issue. I think that goes without saying, and many people are trying to find solutions, technically, legally as well. We don't have an international legal instrument on space debris. States are not bound by obligations in relation specifically to space debris or explicitly in relation to space debris. I think Chris made a comment earlier about the due regard principle, and I think that's a good argument to make. But in the UK, much like in other countries such as France, when an operator comes to the UK and says, okay, the UK, you're going to be a launching state, and therefore you're going to be internationally liable if anything, has to look at that mission and say, okay, well, that kind of places a really big obligation on us. We don't want to just accept this. We want to make sure that if this satellite does collide or if it crashes on Earth, that if we're internationally liable, we have a means of paying the compensation that we are internationally obliged to pay under the Liability Convention. And so when the UK receives that type of application, they carry a very thorough due diligence exercise. And so they'll look at the financial viability of the company, they'll look at the risks that are posed of that particular mission. And within that, they ask operators to provide a very robust space debris mitigation plan. They want to see from an operator that this operator has a very clear plan about what they'll do if there is a collision, what they'll do at the end of the satellite's life, however long that may be, and also to make sure that the materials and the substances on board the satellite are environmentally compliant, if I can put it that way. So there's a very, very thorough environmental impact assessment that's done as part of this due diligence exercise to determine the level of risk. And I think the rationale of a regulator is that by carrying out this type of thorough due diligence and only authorizing the missions that they're satisfied do not pose a risk, or at least one that cannot be quantified in terms of insurance and liability, that if something does go wrong, there'll be an understanding that there'll be a mechanism to provide the compensation that's necessary. But that differs from country to country. I think many countries nowadays have very robust regulatory frameworks. Many also have national space legislation. And this whole debate about debris, I think, does raise a question of, should this just be dealt with at a national level? Because every country has different priorities in space, and they have their own ways of, requiring certain amounts of insurance per satellite. Or should this be governed at an international level? I think that's an interesting debate that we can have, and I don't think there's a very clear answer to which is the preferable route to go down.
Do we have any of the panelists that wants to provide a replica or add something to Nicholas? Right, because then we have another question. I mean, we were just addressing the due diligence, and to me, it's quite interesting seeing that the UK bought the company called OneWeb and thought that this is going to be a company that provides them with a GPS system, while the OneWeb was actually providing just the access to the internet. So maybe, Christopher, you can provide us a bit more information with just how that happened.
Yeah, I'm in a slightly fortunate position being an academic, is that I do have it doesn't worry me whether I'm speaking for my institution or not. They'll happily disown me anyway. But yeah, the OneWeb purchase is really interesting because I think it says two things. Firstly, twinned with the Space Industry Act and the consultation that Nicholas talked about, it shows that the UK is trying to step up its space presence. It's trying to move into the next league of space powers, as it were. I also think it's really interesting because we've all been to space conferences where the private sector has beaten up the government and the public sector and said that they need, the private sector can do it quicker, cheaper, et cetera, et cetera. And we now have a situation where the government is bailing out the private sector. So I think that's another interesting point as well. But the interesting thing from the UK's perspective is that this is something that we haven't necessarily seen before in space, where they're actually putting money in and saying, we think this is a viable proposition, and we think this is going to be something worth investing in. First reason that they invested in it was we've never had proper sort of discussions in the UK as to why they invested. The first reasons that came out were that they viewed it as a potential solution to the UK's difficulties with getting involved with the Galileo program, because we've unfortunately left the European Union. There is technical workarounds, and there is a way in which OneWeb could be reconfigured. But I think somebody in the press said the UK have bought the wrong satellites if they want to do that. And I think that what we're seeing is a number of government ministers also dialing that back and talking about, no, we want it to be for internet from space. And that's what OneWeb was originally intended to do. It was intended to be a sort of a communications internet from space provider. So kind of long way around my answer. I think that we bought it as a statement of intent. We bought it to complement our position in the hierarchy of space nations. And I think now we've got it, we're going to try and make it work as a communications tool and explore potential opportunities that it might be able to use to provide secure PNT information for our military and for our emergency services.
That's interesting. I mean, when it comes to procurement and how these purchases are being made, I mean, Rebecca, we spoke about that briefly, how the whole agency NASA actually looks like and what is the hierarchy in it. Would you mind taking me back to that point and explaining it again?
The hierarchy of the NASA agency?
Yeah, and just how, for example, the funding is being distributed and how these talks are being held.
So, you know, NASA is a federal agency, so all of our money comes from appropriated funds. And the hierarchy is of, specifically with regards to funding?
So the last time we spoke about the vice president being the head of the National Space Committee, and then there is like a very specific process in place, which, I mean, it does not exist in my country. Obviously, we don't even have the agency, but I mean, it's interesting to observe just how big systems actually have very strict rules around that. Yeah,
okay, so, and so the National Space Council is actually not a new concept. The United States has had it in place in the past. I don't know, arguably, if it's been as effective in the past. It depends on the administration and how important space is to that administration that's in place. So the National Space Council, the current one, has been extremely influential in space and space activities. So, you know, earlier when we were talking about just the balance between commercial and making laws and the agencies, and how do we balance all of those interests? One of the really useful things I think the National Space Council has served us, and National Space Council, as I mentioned earlier, is led by Vice President Pence. And I think in regard to that, it shows how much interest space this current administration has in space. This administration has been also very good in providing, you know, it's great that we have great ideas and wanting to go back to the moon, but again, if we're not given the money to be able to do those activities, then they're great ideas that sit on paper. This administration has also been very good on giving NASA the funding to be able to do those activities. They've actually plussed up our budget to do these activities. But the National Space Council, the really amazing thing about it is it's not made up of just government entities. It's made up of the heads of all of your major agencies that are involved in space: Department of Defense, NASA, Department of Commerce, all these big agencies. But in addition to that, it brings in the CEOs of the major companies that are also involved in space. And so they meet on a quarterly basis, and they have discussions and they talk about what's needed to move the country together, to both industry and the government, to make these plans happen, to make going back to the moon by 2024 happen. And so what you see is this concerted effort by both industry, agencies, and everybody coming together and having those discussions on how to best make this happen. And then the National Space Council will put out, basically it's like an executive order that says that then after having these meetings, it says, okay, you know, this is what we've learned. This is how we need to move forward. And it's put in an executive order for agencies to then follow. You know, some of the more effective things we've seen, licensing regimes, how to make our licensing regimes more streamlined to allow for these commercial entities to more easily do activities in space. Export control has always been an issue within the United States. The export control regulations, laws, as well as how to process our licenses, and really streamlining that process, taking a look at our laws, streamlining the laws, again, making it easier for companies to participate and to be competitive in the space regime. So I think, like I said, the National Space Council in the past couple of years has been very extremely effective in ensuring the balance of both industry and government, and coming up with regulations and a path forward for the United States, I think, to move forward in these endeavors, and to possibly then really have a realistic chance of meeting that 2024 deadline.
Thank you so much for that. We also want to hear a bit more about the militarization of space, or perhaps better said, the defense in space. So you just mentioned DoD being on the National Space Council, and it's an area other countries have looked at. So perhaps we can have a round of answers by all the panelists that we have, since having you in one space. What is your perspective? What should be happening in that regard? Nicholas, maybe you can go first.
Can you hear me? Yeah. Yeah, very interesting question. Not an easy one to answer, but none of these questions are, I suppose. I think, you know, since the legal framework for space activities was established at an international level, the militarization of space, the use of space as a domain of potential warfare, has always been a consideration. And certainly, from what I understand, was one of the motivations behind actually creating the first legal instrument, international legal instrument for space, the Outer Space Treaty. And since then, I think it's clear that space has been used for military purposes as technology has advanced since the 50s and 60s. Not necessarily placing weapons in outer space, but using satellite communications for military purposes, reconnaissance as well, the use of military satellites. But what we've seen in the past couple of years is a lot of countries taking increased interest in the use of space for defense purposes at a national level, but also at an international level, to the extent that NATO, for instance, recently recognized space as one of the key domains, in addition to land, air, sea, and cyber, I believe. Speaking from a UK perspective, I think perhaps in response to the creation in the US of the US Space Force, the UK military has been looking at creating an equivalent branch of the military dedicated to space. The UK is in the process, I understand, of drafting a defense strategy. And there are many people within the Ministry of Defense in the UK who are concerned with space and who deal with the use of space technology for military and defense purposes. So this is probably an area that we'll be seeing more interaction. I think the role of defense in space will only increase into the future. And I've just seen that, yeah, one of the comments that was added there was France as well. A lot of countries in Europe are also looking at, you know, national defense strategies for space. France is one of those countries. I think there's also been some discussions, I don't know how formal those have been, at an EU level, about looking at space from a defense point of view. Certainly in the recent EU budget for space, some of the, can't remember the exact figure, I think it was 16 billion euros in total, and maybe about 5 of that was dedicated to not military space explicitly, but the use of space for critical infrastructure and critical communications, which could include military. So for example, government satellite communications. So even at an EU level, I think you could argue that there is some awareness of the need to have a defense, I don't know if it'd be a strategy, but at least knowledge of what's happening and what other countries are doing when it comes to space and defense.
Alexander, do you want to add next?
Well, I was just thinking how to start an answer with my ESA hat, even though I speak in private capacity, because for us, being a civil international organization not carrying out military programs, it's of course a bit difficult to have a very articulate opinion on military space. So let me maybe just add 3 elements that I think are interesting also for the audience listening to us. One is that the military side has always been part of space from the very early day. I mean, it was the early astronauts were all members of military corps, and the strategic dimension of space has never changed. So there is no surprise nowadays that states intensify here and there their military space activities. It was always there. Maybe then at some time you spoke less about it. Also, it's a very European thing to be in discussions, academic discussions, surprised about the military. Oh, there's military dimension of space. Is that allowed? I think, Rebecca, you will agree. In the United States, there's a much more open and natural discussion in academic cycles, but also in industry. I mean, the military space part is a natural part of space. That's one thing. The other thing is that if you look in the existing international space law, if you look in the Outer Space Treaty, there is no distinction between civil and military. The Outer Space Treaty doesn't say states when carrying out civil programs shall do this or that, and when they carry out military programs they shall act differently. It doesn't say civil space objects when they cause a damage may lead to liability, or military don't. So there is no distinction at that level. In the core principles of responsibility, liability, no harmful interference, freedom of exploration and use. And the third is that also from a physics point of view, there is no distinction. A military satellite doesn't orbit Earth in a different way than a civil satellite. And why do I say that? I say that in view of space traffic management, in view of future regulation of space activities, Chris has talked about that before, it will be very important to see how regulatory approaches take into account that whole big military space dimension in the appropriate way. Because as I just said, it doesn't make a difference for a collision avoidance maneuver whether the satellite that you're approaching is civil or military. It makes a difference, of course, practically, because you might not have all the information about the military satellite, or you might have to call somebody or look in a different register. But from a conceptual point of view, in outer space, this distinction, and from a regulatory point of view, is not helpful to regulate space traffic in the most efficient manner. And that's a question we will all have to address, because right now, the military and the civil space domain are negotiated and discussed at different fora, at different levels. And so cooperation and coordination in the future will even be more important than in the past.
That is so interesting that we're making such a distinction. And I'm going to be calling Rebecca next. Maybe just having in mind that Juliana also raised the question, is the Artemis Accords now, in the Artemis Accords, now it is specified that they regulate civil activities, and maybe you can add something to that as well.
Just real quick back to the military. Just wanted to add something to that, because I think very similar to what Alexander said. You know, when the United States start talking about the development of Space Force, there was some criticism, and I think there's this misunderstanding, as Alexander had also said too. The military has always been involved in space activities, and really the Space Force is a conglomeration of all of the activities that DoD was really already doing. And in addition to taking on further and additional roles, but it wasn't that it was this new entity, this completely new entity being formed. And if you look at a lot of other countries like Russia and China, their space activities fall under the military. I mean, it is more directly linked to their military capabilities, and ours have been too. So, you know, as the United States is looking into the future of all the activities that we want to do and are doing, there are a lot of threats in space, and really the Space Force, and because we are a civil agency and we want to make sure there's that distinction between our civil and military activities, NASA can't take on the role that the military would normally take on. So the Space Force is, one of the major roles is to ensure the safety of our space assets in space. So just maybe giving that further explanation of what it is for the United States as I understand it. Your other question with regards to Artemis Accords, could you repeat that please, Anya? My apologies.
Yeah, sure. So the Artemis Accords, that was actually a question from Juliana. It now specifies that they regulate civil activities. Would that mean that the military activities are not included at all in the Artemis Accords? Or maybe Juliana, you can actually add a bit more to that question, just to specify it. You can also unmute yourself.
Well, so with regards to the Artemis Accords, again, that's a NASA agreement. So we wouldn't be mixing civil with regards to the Space Force. So I think that goes into what I was saying is we really do try to keep them separate. Where the Space Force, where I would see the Space Force being involved is, again, is they will be protecting those assets. So if there are activities on the lunar surface, it would be the responsibility of Space Force to protect those assets. Does that go to answering that question? It's just that we're always, you know, again, it's the distinction between civil activities and military activities, and the US are keeping them separate, but then the purpose again of the Space Force is the protection of those civil activities.
Thank you so much. I'm going to be giving the word to Jenni. And there is another very interesting question as well, just popping up in the chat. So I'm going to be reading that out loud. How many military satellites are registered as such? That is a very interesting question. Like a couple of years ago, I've done a research on that. And to my surprise, I saw that like we are very good with registering the civil satellites, but lacking the registry for military satellites. And I thought that was always like, what is happening there? There is no transparency, but possibly there's reasons for that. So yeah, looking forward to those answers as well. Jenni?
Yes, well, I mean, for someone who's more into the peaceful than the military side, let's say, I mean, just also because of the distinction between the UN processes that we have in Vienna and those that we have in Geneva. So let's say that I'm more inclined to sometimes say that this distinction is not so interesting, especially when we talk about these common issues such as space debris and the use of outer space for whatever use that is. There is certain collaterals or certain problems that are let's say something that is for any use that we have. So in a sense, it's interesting not always to have that, let's say, long-lived discussion, for example, that what do we mean by peaceful, or what is military or non-aggressive at international law level, for example. But maybe there is at some point the discussion that what do we mean and what are the extent of use and exploration of outer space, that are there such certain uses that are less permitted than others, or are there certain uses that are more preferred than others, so that this, let's say, forming the common understanding on what do we mean by use and exploration of outer space, and what sort of usages are within that definition. So this is a discussion that I think we should definitely continue to have at international level.
Thank you so much. And just to conclude, I'll actually give the word to Christopher as well. And then we're actually about to finish this session.
So looking at the Outer Space Treaty, they're looking at the Liability Convention, they talk about space objects. They don't talk about civilian space objects. They don't talk about military. They talk about space objects. And I think, again, to go back to my points on space traffic management, if we're talking about understanding the space environment, we need to know everything that goes on up there. And one thing I will say, the military, especially the US military, have been great in providing information about what's actually going on in space, providing conjunction analysis. And, you know, so the military uses of outer space, whilst not necessarily being benign, it certainly has contributed in a positive way as well. I think what I would say in terms of the way in which the military are dealt with and the way in which military activities, I've got two sort of words for you. Well, one's two words, but it's same concept: data sharing, transparency. The more we know about the space environment, the more information we share about the space environment, the more we deconflict activities. You know, something happens, a satellite goes near to another satellite. Should I be nervous about that? Is that satellite going to cause my satellite a problem? Well, if we know what it's up to, if we know what it's doing, if we know why they're there, then it's not going to cause a problem. I think the problem with, and the reason why the register isn't quite so informative on military satellites is because obviously they're not going to say that satellite there is keeping an eye on country X, or it's keeping an eye on country Y. So I think we need to understand there are going to be limits to military cooperation, but I think the more we can share data, the more we can share information about the space environment, and the more we can sort of work in partnership with the military on that, the more rounded a solution we're going to have for the management of Earth orbit.